All right, guys, we're going to call this meeting to order. We are going to proceed. In advance, I will tell you, we're going to take this up because there's a multitude of issues to discuss that have come up. But first, let me make everyone here aware that, unfortunately, the new O1s and O2s do not match the copy of the substitute bill you have before you. So I'm not comfortable with voting on this until every member is holding the right LC number. We are trying to get those copies made right now. If we can get them, we'll vote on it. If not, we're going to have to postpone. But we are going to go ahead and take up the issues because the language, Representative Smith, thank you for being here. The language is almost the same. So we're going to let you explain the measure one more time. We have some issues to discuss that relate to the long-term care ombudsman. We have some issues that relate to the nursing home industry to discuss. We have several issues to discuss, and we have a provision that has been added since we had a hearing before on this. So we're going to discuss all of that, hopefully while getting copies of the actual substitute. So, Representative Smith, thank you for being here, my friend, and if you will go ahead and explain the measure again, and please explain anything that might be different in the version that we're looking at, and that is 0426S. Is that the one you're looking at? Okay, thank you, sir. So 0426S, that's what we're looking at, and the new sub we don't have, you explain any difference therein. Thank you, sir. Let me put you on.
Thank you, Mr. Chairman, members of the committee, for this opportunity to present HB 906 again. And as you guys may know, this is a straightforward bill that requires long-term care facilities that maintain a website to post a link to the official website of the Georgia Long-Term Care Ombudsman Program. Now, since our last meeting, I've worked with facility representatives and legislative counsel to address concerns that were raised, particularly regarding penalties and implementation. So let's go through them. First, the bill will include an effective date of January 1st, 2027 to allow sufficient time for compliance. In addition, the penalty structure has been clearly defined. The first violation would be a written warning. The second would be a $100 fine. Third and beyond would be a $200 fine. Broken links alone would not carry any penalties whatsoever. And also, there is no risk of license revocation under this section. Now, compliance would fall under the Department of Community Health's existing oversight structure. Any civil monetary penalty will be handled through DCH consistent with its current administrative processes, and collection would follow the same procedures already used for licensing-related penalties. Additionally, language has been added to clarify the scope of medications a qualified medication aid may administer. Existing law already permits medication aids to administer insulin, epinephrine, and B12 pursuant to physician direction and protocol. This revision simply adds GLP-1 medications, which are typically used to treat diabetes, to that existing list in assisted living communities and personal care homes in accordance with written physician instructions and established protocol. Those are the changes, Mr. Chairman, and I'm happy to answer any questions.
Thank you, Representative, for the good explanation. And as everyone's aware, we've heard this once before, and some of the changes were alluded to. The first question, I have a question for you, and I know Ms. Humberstone is here and mentioned this to me as well. So we already have physical plant requirements. Every facility, whether it's a skilled nurse facility, assisted living community, personal care home, must post prominently in the facility access to our long-term care ombudsman program, and we're going to hear from our state long-term care ombudsman in a moment. But the new port, what we see here that we didn't have before as it relates to your original bill, are penalties. So can you speak to why those penalties were added and where they came from? And I know Ms. Humberstone had worked on some of that with you as well.
Absolutely. From my understanding, Mr. Chairman, is that those penalties that if someone if the long-term care facilities fail to post that information on a website, those penalties will be consistent with the same penalties that are inside the building for failure to post. So we wanted to make this section specifically about the penalties on the website.
Okay, and Ms. Hare-Paul, can you tell us precisely what the penalties are? If you could, and even if it takes a minute, can you discover for us the penalties currently for a facility that's not posting it prominently on the physical plan? Because we talked about it earlier, and I know you've tried to make them consistent, but maybe not precisely with the. My understanding is you reduce the penalties.
Absolutely.
So I want to make sure. So for the body, it'd be good for us to know, to compare, if you could find those for us. And I know you didn't draft this bill, so I apologize. Yeah. Ms. Humberstone, if you can speak to that, or Ms. McNeil, if you would like to address that. I'm sure you, maybe both of you, if you don't mind. Yeah.
Mr. Chairman, members of the committee, Sheila Humberstone with Georgia Healthcare Association representing Georgia Skilled Nursing. I did help the author write the penalties, and I did not look at what was the penalties in the physical plant. I just worked with the sponsor to make sure he wanted to provide some teeth in the bill, but he also wanted to make sure that we weren't kicking residents out of a home for broken links. So we worked together to try to find some rational middle ground on what would be an appropriate set of penalties. So that's sort of the charge that I had and what I tried to put on paper. But I'm sure Ms. McNeil can tell you about the penalties otherwise. Thank you.
Thank you so much. And members, this Ms. Melanie McNeil is our state long-term care ombudsman and one of the finest in the country, in my opinion, and does a remarkable job protecting Georgia seniors in facilities. Thank you.
Thank you, Mr. Chairman and members of the committee. I actually don't know what the fine is, but in my 15 years as a state long-term care ombudsman, I have never seen a facility fined for not having a poster up. But what has happened is we had one facility that didn't like the design because they had redecorated, and so they put up their own poster, and we went in and said, you can't do that, and HFR backed us up. They didn't fine them. They just said, take down the poster and put up a new one. If they post the poster behind the employee's room door, if our ombudsman representatives go into facilities every quarter and they look for those things, if they can't find the poster, they'll just go to the administrator or the executive director and just say, hey, where's your poster? Oh, well, it's behind a post. And we just say, will you move it, please? And they do. So I don't know that the fine is really going to be an issue for facilities. I don't think it will, but I'd be surprised if they're ever even fined.
Thank you, Ms. McNeil, and I think you're getting to my point. If indeed, we've long worked that way. Every provider wants people to know how to get the ombudsman, and so if we don't have it for the physical plant, which we've had as a requirement forever, it may be that we don't need it here. Or maybe we do need it here. I thought maybe there was an interest in being consistent. So we're looking for that. Ms. Hare-Paul, can you maybe reach out to Mr. Hennessy and ask him? I'd like us to know the answer to that question before we do anything. All right, we have a question from Chairman Bonner.
Well, thank you, Chairman. So my questions are related to the fees. I think it is important to know those amounts, and then more specifically how they're calculated. Is it a per occurrence, per day, that kind of thing? And then if there's any kind of appeals process for that. And then finally, just to understand, is it similar to like a health code score that would be made available to the public in terms of any violations that a particular facility had, so that the public can determine, again, almost like a health score for a restaurant, to see what it was and then what they did to make it right and be in compliance. But those are the only questions I had, Mr. Chairman.
Thank you, Chairman Bonner. Representative McDonald.
You want me to answer your question, right?
Well, my understanding is we're getting that information.
Okay, perfect. Thank you.
But But
Okay.
but those are the questions I would have once we have those specific amounts.
Okay.
Chairman McDonald.
Thank you. Thank you, Representative Smith. Looking at lines 42, 43, and this is not only for Representative Smith, but also for our state ombudsman. It says if a long-term care facility violates any provision or subsection of this code section, the department shall be authorized to. It's not saying shall do it, but be authorized. So this would be a question maybe for you and the ombudsman. It's giving them the authorization, but from what I heard in her remarks a few minutes ago, they like working with people. They're not there to find people. But yeah, I understand you got to have teeth in a measure because people then wouldn't even care and would not move it after being told by the ombudsman. But I'm reading this, it shall be authorized. The person that goes out for this inspection still doesn't have to find even on the second time. They're just authorized to do it, if I'm reading this correctly.
Thank you for those remarks. That's the way it reads.
Representative Campbell, let me see if I can find you here. See if that's got you.
I don't have a microphone.
Oh, you don't have a microphone.
Thank you,
Sorry.
Chairman. I just wanted to say I really like this bill. I think it is a tremendous and very obvious step in today's world to have a website and technology available for families to be able to learn information. So I really, again, appreciate bringing this bill. And I think just in terms of the conversation around the penalties, it sounds like all of the experts here have agreed that these are issues that typically don't happen, and when they do, these seem like the minimum standard is really the base in terms of fines. So more of a statement than a question. Thank you.
Thank you.
Thank you, Representative Campbell. Chairman LaHood.
And thank you, Representative Smith. Appreciate you bringing the bill and promoting transparency for consumers and everyone that's worked on this. I just want to go on record and state, kind of second what's already been said, but I see this as a professional in this space as additive, not deductive in any way, or this is just an additional measure to improve transparency, and the penalty section is just for some clarity. And like Chairman McDonald pointed out, it gives the department an authorization to issue these fines if they see necessary. But I agree with Ms. McNeil that this is not an industry problem. If it does become a problem, it's easily corrected, and nobody tends to get hurt. So I appreciate this additive measure for additional transparency. Thank you.
Thank you, Mr. Chairman.
Representative Bazemore.
Thank you, Mr. Chairman. To my colleague and friend, thank you so much for bringing this bill, and thank you for the clarification of the shall. So now we have a clear understanding. And Mr. Chair, at the appropriate time, since we all now have the correct copy.
Thank you, Representative Bazemore. It is not the appropriate time. We've got some fixes to make, in my opinion. All right, so here's, so let me say this. The reason we're hearing this bill is because I believe, and I think all of us believe, this is a good measure. And I appreciate the representative, and I told him so. I had an experience over the off session where one of our skilled nursing facilities was closed, was actually terminated in Savannah. And a lot of those residents reached out to me, and there's occasions where, folks live, I might live in North Carolina and my mother may be in Georgia. And I might not see that poster that's posted in a facility, and it just might be helpful to have this information on a website. I think the issue we're trying to address is that right now it appears to me that the requirement on posting in a facility may be strictly through regulation and not through statute. And so I'm trying to be consistent with how we manage it. And so as it relates to the penalties, when the requirement is to do this, and it sounds like our state ombudsman is facilities do this because they know it's the right thing to do. They're going to do this when we pass this either way. The penalties may be inconsistent and we may remove them, but that's what we're here to discuss. All right, everybody should have before you now, and Representative Smith, want to make sure that the version that we needed, we now have, and that is Representative Smith 9005S. Is that correct, sir? 9005.
I just wanted to make sure the language is correct. Yes,
Sir.
this is the
Yes, sir.
correct
Okay,
one.
so every member should now have this version. Okay, that was very good. All right, so now want to make sure everybody's looking at the right version. I'm going to set this old one aside. There is one more issue that our state ombudsman wants to address. So, Ms. McNeil, once again, if you will speak to your concern.
Mr. Chairman and members of the committee, I really appreciate Representative Smith's wanting to raise the visibility of the Ombudsman program. So I don't disagree with that, but I'm very concerned that, and I have not seen the substitute, but the language in there just says put a link to the Ombudsman program. So my concern is that when people are looking for an independent advocate, they're not going to see that on the website. All they're going to see is a link. And so they very well may think that the facility is saying, we have an ombudsman that's affiliated with us. And so if a resident's got a concern, they've already got a problem with the facility, they're not going to go to somebody else who works for the facility. But our program is independent. So, and it's authorized by federal law. It's required, actually. Every state and the territories have state ombudsman, long-term care ombudsman. So I shared with Chairman Petrie some language that I think if they're going to put it on their website, another concern is where will it go? Will it go on the last page, which is 19 of 19? But I don't really have as big a concern with that as I do just what the language is. So rather than just a link, I think it would be helpful to have some language that says the Long-Term Care Ombudsman Program is a federally authorized independent program to help residents of long-term care facilities, nursing homes, personal care homes, and assisted livings resolve problems. That it's confidential and the service is free. And then the link. There, in that way, people going to the website can see that the facility is including this information. But hopefully it's clear by that phrase, that paragraph, that it is an independent entity.
Ms. McNeil, we discussed this morning. Is it true that your concern is, one of your concerns is that people that are looking at this, we don't want them to think that your long-term care program, protective of resident rights, is somehow attached to or part of the facility or the organization, but it's distinct, and you want a description of that?
Yes.
And your concerns would be resolved if we did that?
Yes, and I'm asking that you use specific language. Don't just say facilities must put some kind of qualifier, because then every entity, every personal care home, assisted living, nursing home will say something different. And we know that sometimes that consistency isn't as accurate. I mean, that language isn't as accurate as it might be. So while on the one hand, you don't usually want to be that specific in the law, in this case, I think we need to. And then the link is to our website. Now, I thought, well, you could also put the phone number, but phone numbers change. So don't put the phone number, just put the website, because our phone numbers are on the website. So, yeah.
And I know we're going to get moving here in a minute. Yes, ma'am. Miss Lupton, let's, no mic, right? Okay.
I understand, I hear your concern, and I think I understand it. We've got the posters already, and I've worked in nursing homes, I've seen them. Is it sufficient enough to say that basically what's on that poster needs to be put online? Because, I mean, I've seen the posters in facilities, and I don't get the, I don't think, oh my God, that's something that this facility is set up. It's very clear from the poster that this is something that, if you're having problems with this facility, call these other people. I
Right.
think the posters say it very well.
Yeah.
Would it be sufficient to say, like, take what's on that
Very good point, Representative. I think we're going to move in a very similar fashion. Representative Okoye.
Yes.
Yes.
I'm sorry, I didn't catch that part. Yeah, yes. Yesterday we had some communication back and forth.
All right, if there are no more questions, so here, okay, oh, I'm sorry, Miss Representative, I have a problem, Miss Edna. I tend to call you Miss Edna because I love you so much. So Representative Jackson, I'm sorry.
Thank you. I'm happy that all of this has been cleared up. I was at the center in Savannah, and it was chaotic. I was there for 2 days. The people knew me over at that building because my grandmother was a patient, an aunt was a patient, and it had been an excellent center. So I'm glad to hear that some of this stuff is being cleared. My question is, in as much as, you know, a lot went on, has there been anything else? Yeah, what I'm hearing is we're clearing up stuff that has been in existence. Apparently, I was not on the committee when some of this, you know, these clarifications are coming, or I missed a meeting, and I stand corrected for that. But to see what happened with those people that were there, the crying, and this, I called the chairman about all of the incidents that were happening there, because that was protocol. So I'm very partial about stuff like that, and I just think our elderly people need to know that they have people looking out for them, and at that time, they didn't feel that way. I drove in from here straight to that place. So I'm glad that as long as the person that is presenting the bill and we're in a court, that's good. But please, I have some recommendations later that I would like to tell you, that I'd like to talk to you about, that I think would make it even more efficient.
Thank you, Representative. We're going to take one last question. Representative Fry has a question.
Thank you, Mr. Chair. And I'm probably going to say what's already in your head, if that's okay. That the language seems okay. Actually, and you may not be thinking this, that if these penalties are lower than what's in code, I think that would be acceptable in the idea that we would be offering some potential relief, especially since she indicated that the ombudsman indicated that there haven't been penalties actually assessed. And so we could codify those penalties, but then also to address Chairman Bonner's question, we just would add a friendly amendment to make it quarterly. You know, so you have 3 months to correct an issue, and then we would go from there. So I feel like we're really close, and I just want to let you know that I support the bill.
Thank you, Representative Fry. I think we're all very supportive of this measure. I think that what I've learned, and we're still trying to learn more, is that this is not addressed in statute for the current requirement that's always been in existence. It appears it's only in the rulemaking process. And so if we put it in statute now, it's in statute for this part, and it isn't for the balance of it. And it appears to be the case. I could be wrong. I don't know that. But right now, we can't find it in code. And so that is my concern. All right, so I'm going to mention, and then we're going to move because we're going into session in a few minutes. So we're going to move swiftly now. Thank you to our state long-term care ombudsman, Ms. McNeil, so very much. So here's what I'm going to do. We are going, so everyone understands we're just adding GLP-1s to the ability for, now, and I'm going to ask Chairman LaHood to maybe address this for me real quick, and then we're going to move swiftly. Chairman LaHood, my understanding is you've worked with Representative Smith on this, but it appears that right now this measure only allows certified medication aides to do the GLP-1s in personal care homes and assisted living communities. This does not address skilled nursing facilities, is my understanding when I read the version I'm looking at. Is that, and to our legislative council member, I would ask that question as well. And let's hear from Chairman LaHood, and then we'll come to you, Ms. Harrapal.
All right. Thank you, Chairman, for that point of question or clarification. So currently, certified medication aides in assisted living and personal care homes can administer, are allowed to administer insulin, epinephrine, and B12. GLP-1 is a newer insulin treatment, and we just need to add it in code to make sure we're compliant there and can treat, can follow physician's orders when that's recommended. For skilled nursing homes, they're don't use certified medication aides or are not required to. They're skilled nursing and have nurses on site, and so their scope is much broader.
Okay. My understanding was some of them do use certified medication aides as well, though, was my understanding. Maybe not, but I thought it might be helpful for them to have it as well. Sounds like, and our nursing home folks are here, you're good with this language? Okay. I just want to make sure we didn't need to add skilled nursing facilities. And then to Ms. Harrapal, one last question. The code section relates to hospitals and other healthcare facilities. Then it specifically alludes to, in Section 1, personal care homes, and Sections 2, assisted living communities. Are we capturing skilled nursing facilities in this or not with Section 1 and 2?
Chairman Petrie, and Ledge Council, on line 12, it does mention other healthcare facilities.
Right.
So does that capture skilled nursing?
Well, so that's the section it's in, but then it specifically mentions in the code section, when you get down to 7-12, it's relating to personal care homes. So I think we're not touching skilled nursing facilities, but okay. Okay, so it sounds like we have an agreement that right now this is just personal care homes and assisted living communities. Okay, got it. All right, and I see no protest about that. Is that okay? Gotcha. All right, so here's so what is the will of the body, and then we're going to move swiftly. What is the will of the body? Representative Bazemore. Hold on one second. Representative Bazemore.
Thank you, Mr. Chair. I ask that do pass.
All right, we have moved do pass. We have a second? I second. Okay, all right. Now for discussion. So here's what we're going to do. I'm going to make an amendment first, myself, and then I have another amendment coming from my vice chair. All right, first amendment is this. On line 41, in the version you're looking at, 9005S, on line 41, after the word ombudsman, period, we state the following, and I'll go slow there to our legislative council. We'll state the following. The link shall be preceded with the following statement. The Long-Term Care Ombudsman Program is a federally authorized, independent organization that helps residents of nursing homes, personal care homes, and assisted living communities resolve complaints, period. The service is confidential and free of charge. www.georgiaombudsman.org. That is Amendment 1. Any discussion? Okay, I'm sorry, I'll get you in a minute. All right, now we have, all right, let me get you on here. Let me get this one off. All right, Vice Chairman?
Thank you, Mr. Chairman. I'd like to offer another amendment to to remove strike lines 42 through 52, the penalties part.
Or through 53, actually.
53, sorry.
So Amendment 2, Cameron, strikes, that puts it back. So Representative Smith, what that does, it puts it back in the posture of where you began. Your original bill did not have any of that language, and it simply puts it back into where you began with your bill that we heard in our first meeting, correct?
But I don't want it to be in the same section. So if there are penalties, I think we know that there aren't any fines. But if there are penalties, I don't want these to be associated with them.
Let me get you on. Let me get your mic here. Go ahead. We've got your mic now, Representative. Your mic's on, Representative. Got very limited time. My understanding is what we just described puts it back to the way we saw it when you brought this bill originally. We have a requirement that every facility in the state must have on their website the long-term care ombudsman, but we remove the penalties. I don't believe right now we have enough information to know that this is in any way consistent with what we already do, and no one in the room has been able to answer that. So if you're good with that, right? But I want to hear from you, Reb. This is your bill, so you're the most important person in the room to me right now. So use your mic. I have you on. Your mic is on, but I want to make sure that we're putting it back to your original posture, except that we do have the GLPs in here. So that has not changed. But as it relates to penalties, we're removing those. And then we're adding, my amendment makes our long-term care ombudsman program, the people that spend their life protecting seniors, it makes them more comfortable with how we put it on the, so are you good with these amendments? That's important to me.
At the moment, I would like for Chairman LaHood to share his remarks.
Okay, thank you, Representative. Okay, Chairman LaHood, quickly, please.
Thank you, Mr. Chairman. The reason the industry folks recommended the penalty section is for clarity and to make sure the department didn't impose penalties that were not clearly defined at their discretion. However, upon thinking on this more, and I'm looking over to the industry experts over here, I believe every violation that the department could cite has a letter beside it, like a tag, A through F or G, or, you know, and each one has a different level of severity. And so I'm curious where this falls in that severity scale.
Yeah, it appears that the requirement...
Would a fine already be defined next to the letter that corresponds to the severity?
It appears from what we can learn from Legislative Council, the current requirement that's long-standing has no such language like this anywhere in statute. So we would be bifurcating this. So let's do this. It's 8:47. Here's what we're going to do. And this measure can be addressed in the Senate. It can be addressed when it comes back to the House if we learn more. These changes were made at the very last minute. I saw them this morning. So here's what we're going to do. All right. We're not going to have any further discussion. We're going to, so on Amendment 1, on the Petrie Amendment, which adds, the link shall be preceded with the following statement on line 41. I read that out. Ms. Harepaul, can you read back that the first amendment? Okay, all right. All right, I'm going to read it. All right. All right, on line 41, the link shall be preceded with the following statement. Quote, the Long-Term Care Ombudsman Program is a federally authorized independent organization that helps residents of nursing homes, personal care homes, and assisted living communities resolve complaints. The service is confidential and free of charge. www.georgiaombudsman.org. Motion on the amendment, a second on the amendment. All in favor of, we'll call it the Petrie Amendment, say aye. Aye. All opposed? Okay, and I think, Ms. McNeil, this makes you more comfortable, correct? Okay, very good. All right, that amendment is passed. We're now on to the Cameron Amendment. Can you describe that again?
Yeah, to remove lines 42 through 53. Take out the penalties part.
Okay. What's the will of the body? Cameron Amendment.
Move to pass.
All right, a second. Do we have a second on the Cameron Amendment? No? All right. Sounds like the Cameron Amendment fails. All right.
All right.
So, now, here's where we are. We're back to the original bill. The original bill has one amendment. It keeps the penalties in. Okay? All right. That is what you're looking at. Everybody clear? You're looking at this bill with the penalties and with the amendment. All in favor? You move to, we already have all right. Second? All in favor?
Aye.
All opposed? Okay? All right, the bill passes in that posture. All right.